Welcome, Mr. Fenwick.
Thank you.
Now, let me explain the setup. You're talking to a select audience here at Aldwych House. There are participants in front of you and the public. There may be representatives of the press at the back, and the lawyers are to your left. Mr. Hill will ask you questions in a moment once you've been sworn. But you're talking beyond this room to something in the region of 100 or so people who are watching online, live streamed and YouTube as we go along.
Very clear.
Rose, would you administer the oath, please?
Please take the book in your raised hand. Please state your full name.
Justin Francis Quintus Fenwick.
And repeat after me. I swear by Almighty God.
I swear by Almighty God.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you.
Mr. Hill.
Mr. Fenwick, is it right that you're a barrister and a Queen's Counsel?
It is.
You came to the bar after a career in the Army and the Grenadier Guards, and you were called to the bar in 1980.
Yes.
Completed pupillage in July 1982 and became a Silk QC in 1993. Is that right?
Correct.
You remain in full-time practice as a barrister, and is it right that you've also sat as a judge in the civil and in the criminal courts?
Yes, until the statutory age for retirement 3 years ago.
You are able to give evidence today, and indeed in your witness statement, because your former clients have waived privilege. Is it right that you give evidence as an individual and not as a representative of your former clients?
Yes, it is. I have clarified with the department in writing that I come here not to speak for the department or government or any of my former clients, but as an individual doing my best to recollect and recount what I remember of those days.
Aside from your memory, is there any impediment to you giving your evidence today of professional obligations or any other form of obligation?
Not that I'm aware of.
You have a copy of your witness statement with you?
Yes, a blank one which you kindly provided.
Thank you. I'm going to start by asking you a few questions about your career before the HIV litigation. You were instructed in the pertussis vaccine litigation, according to your witness statement, at paragraph 2.1. Is that correct?
That is correct. One of the individuals involved in pertussis vaccine research, Professor Miller, was a person of with some involvement, and as a result of that, I was instructed and came to understand a little bit about the pertussis vaccine issues.
Were you then subsequently instructed by the licensing authority and the Committee on the Safety of Medicines in the Oprin litigation?
Yes, I was.
That litigation concerned the safety of an anti-arthritis drug, and it involved questions of whether the Committee on the Safety of Medicine and the licensing authority owed a duty of care. Is that correct?
That was the preliminary, that was one of the issues. There were also, of course, issues as to whether there was any breach of duty, if there was a duty owed.
And is it right that the cases against the Committee on the Safety of Medicines and the licensing authority weren't ultimately pursued, and the litigation proceeded against the manufacturer of the drug?
Well, no, the litigation proceeded against all. The manufacturers, Eli Lilly, at some stage entered into a global settlement with, I think, all those except those they considered to be statute barred. There was then a limitation hearing at first instance where I think only one plaintiff was permitted to continue under Section 33, and then there was a hearing in the Court of Appeal whose outcome I cannot now recollect, but in the end no allegations were in effect pursued against those authorities. So the issue was never resolved.
And is it right that neither the Committee on the Safety of Medicines or the licensing authority contributed to the settlement that was put forward by the manufacturer?
Correct, absolutely nothing, nor did central government.
You were also instructed, according to your witness statement, in the benzodiazepam group litigation
Yes.
on behalf of, again, the Committee on the Safety of Medicines and the Licensing Authority.
Yes, I don't think the department was involved in that. I recollect those two.
That overlapped in time with the HIV litigation, but continued afterwards.
Yes.
In your statement, you say that the claims were later abandoned after substantial costs were incurred. First of all, is that right? And secondly, was that a result of the Legal Aid Board withdrawing funding?
I believe so. From recollection, there was something astronomical, like I think it might even have been £30 million. It was certainly £15 million or more was spent by the Legal Aid Fund on it, and they didn't even get to the stage, I think, of there being a defence served before it was recognised that the merits were not such that the Legal Aid Board would continue to fund it.
When you say there was that money spent on it, in effect, that money would have gone to the lawyers rather than the plaintiffs in the case.
I regret to say it would, and there was, of course, money spent out of the resources of the Department of Health Licensing Authority on defending the case.
I'm going to turn now to the HIV litigation, and the bulk of my questions today are going to be about that.
Yeah.
May I begin by asking how much you were able to recall of your role in the litigation independently?
It's always a difficult question when you have material supplied to you. When I first was asked if I would give evidence, and before I looked at the two fat volumes of documents which were provided to me, I had certain overriding recollections of it in terms of its general structure, the plight of the individuals, because I then went on, as you will cover, to human growth hormone and BSE and CJD. So that was very striking. I also had a very clear idea of the view we formed of the legal merits. And I have a strong overriding recollection of my view throughout that although we would win the litigation, the effect in terms of the public perception of the suffering which had been endured by the haemophiliacs would lead in any event to a massive outcry for public inquiry. So that's my recollection before I read the papers. I've now read the papers you provided to me. I've read nothing else apart from reminding myself of the variant CJD scheme because it was relevant to one of your questions. And quite a lot has come back, but the extent to which it's reconstruction from the documents and recollection is difficult to disentangle. I have tried in my statement, and I will try today, to make that distinction between what I remember and what I believe I would have done or said at the time. It is difficult, and I'll do my best.
Thank you. It appears from the documents that we provided you with, and you mentioned this at paragraph 5.1 of your statement, that you were instructed in about mid-1988, at about the time when the writs in the litigation were served. You were instructed by the Department of Health, the Licensing Authority, and the Committee on the Safety of Medicines, and we'll explore the different interests that those groups had.
Yes, probably initially by the Treasury Solicitor. There was a change around that period. Until about then, all litigation was conducted of this kind of level by the Treasury Solicitor with input from departmental lawyers. I think over this period there came a shift and the departmental lawyers became the instructing solicitors formally, whilst the Treasury Solicitor was in the background. But I can't recollect the exact legal structure of it. In those days, of course, barristers didn't have contracts, so it was where they came from. But in essence, the instructions were on behalf of all three of those bodies.
Were there any concerns, either then or later, that there was any conflict of interest between those three bodies?
There were no concerns. I and the other barristers, and I think all the lawyers, were aware that there could come a time when there was a conflict. For example, if the department wanted to take one view in order to resolve the matter of not taking a particular point, which was important to the, in those days, I think about 25 or 30 individuals on the Committee of Safety of Medicines, all eminent doctors. There never came such a time, but we were always, as in all litigation where you have multiple clients, aware of the possibility.
I'd like to just quickly run through the names of those who were on your legal team, because they'll be cropping up during the evidence today. You were the only junior who was instructed throughout, is that right?
I was the only junior who was instructed throughout. As I read the papers, including some papers very recently sent to me, there were, in addition, I think Michael Spencer was already a QC when he joined us. He became a silk at about that time. Fiona Sinclair was, I think, my pupil and turned up at one court hearing. Helen Rogers was involved at some stage. She sadly died of acute asthma a few years later. But in effect, I was the only junior.
Was it unusual that you would be the only junior on such a large case?
Not in those days. The large legal teams we see today were not popular, certainly in government circles, in those days. I mean, in Operan, the manufacturers had several counsel. The plaintiffs, as they were then called, had several counsel. I mean, you have to recollect back to a period when almost all government litigation was conducted by the Treasury devil. When I started, Simon Brown went to the House of Lords, then John Laws, and it was delegated down to the panel. But it was, I think, quite usual for there to be a very small legal team and quite normal for juniors only to be instructed. The Treasury devil never became a QC by tradition, so the introduction of QCs into defence teams in those days was unusual.
Did the size of the team during the HIV litigation cause you any problems in terms of being able to keep across the issues of the documents?
I don't recollect it. I was a lot younger then. Probably had a bit more energy. I don't remember. I mean, I had another caseload of various types of litigation. I don't remember ever thinking, I need more resource. Of course, the resources of the department and those helping the licensing authority and the CSM were stretched. But I don't recollect there being any sense that we can't do it because we haven't got enough men on the team. If we had, I would have said so. And I think that by that stage, I had sufficient influence within the department. If I said, I need more help, then we would have got it.
And of course, you mentioned that Fiona Sinclair and Helen Rogers, their names appear in some of the papers, so they would have assisted at some point.
Yes. I don't think they had much involvement. They may have helped me at certain stages, but that's in the midst of time, I'm afraid.
You were led by Andrew Collins QC, who was a senior member of the Common Law panel of the Treasury Solicitor at that time.
Yes. I think technically, just your earlier question jogged my memory. I think technically, as soon as he took silk, he ceased to be a member of the panel, but because he'd been on the panel for 20 years or something, he was one of the silks they called upon. I think he took silk when John Laws was made the Treasury devil, because the two were in line with each other for the job. But he was very much regarded as a senior member of the panel instructed by the department in those days.
And also, you mentioned earlier Michael Spencer, who became a silk at or around this time. You say in your statement that his speciality was medical negligence and pharmaceutical litigation. He was brought in to add that expertise. Yes,
I mean, he came from outside the tradition of the Treasury panel. He had been involved for the manufacturers in Operan, and therefore had developed with me an understanding and awareness and familiarity with group action and group action litigation. And he has very, very substantial medical pharmaceutical knowledge. So he was an obvious add-on when we wanted to have some more strength, rather than adding a junior from the panel who might not have the experience of medical matters.
Your solicitors, and you mentioned the distinction between the Treasury solicitor and the departmental solicitor. It was Jayant Desai for the Treasury solicitors and Ron Powell for the Department of Health.
I think that they probably were the lead people. When I was writing my statement, I had quite a lot of difficulty remembering it. Jayant Desai, I think, was involved for the Treasury solicitor quite a lot during that period. He was probably the lead solicitor. I've seen documents from him. Ron Powell, I recollect. There were others, but quite what part they played, I can't remember.
When you say there were others, are those other solicitors, or were you receiving instructions from civil servants as well?
I was always receiving instructions from solicitors, but there would be civil servants present at the time. And, I mean, if one goes back to those days, 35 years ago, when barristers held conferences and consultations in their chambers, in their rooms, with 6 or 8 or 10 or 12 uncomfortable chairs, with people sitting there taking notes on their knee, it wasn't always possible to work out who the juniors were and which ones were lawyers and which ones were officials. So I may have been asked or told something by an official, but it was effectively channeled through the Treasury solicitor and the departmental solicitors. Was
there any individual or individuals that stuck in your mind as being particularly important as to the way the case was argued and the instructions that you were given?
Not from memory. I mean, I can see 1 or 2 people writing notes with firm views as I've reviewed the papers. I mean, I think Andrew Raymond was involved and had pretty strong medical views. There were 1 or 2 officials who had views about precedents and so on, but really which one it was, I simply don't recollect.
You mentioned Dr. Raymond and strong views. Did they have a particular influence on the way that you ran the case?
No, I mean he was a source of information, because certainly I am not an expert on either haemophilia or HIV, although I got involved to a certain extent with Professor Miller when I was doing pertussis. He was, if you like, the person we asked when we wanted to know the answer to a technical medical question, I think, and he would write papers, as far as I recollect. But he's the only one of the doctors who remains in memory.
Was there anything unusual about the way in which you were instructed and the instructions that you received in the HIV litigation?
I don't think so. I mean, we were going through a period when the traditional A2 instructions tied with a piece of white string because it was government work were being replaced by much more informal instructions. We, of course, had nothing like emails in those days, so quite a lot was verbal. There was a certain amount of instructions in writing. And it was a big and complex case. And although Opron was a big case in the sense that there were 3,000 claimants, the vast majority of the cases were of mild symptoms of brittle nails and so on. There were only the very rarest of cases of more serious things. I think were 2 cases of renal failure. So it was a very different kind of case. So I think we talked about this case a lot more because it was important, and as you will no doubt come on to, it clearly attracted the attention of ministers, much more so than Opron ever did.
I'm going to move on to some of the papers and some of those issues, but before I do, and to assist those who are following the evidence today, could I just ask for some fairly, if possible, straightforward explanations of some of the legal concepts involved in the case? It's always dangerous asking a lawyer for an explanation of legal concepts, but one of the issues that was raised was breach of statutory duty. Could you explain to those listening and watching what that concept meant?
Yes. I mean, I haven't dealt with breach of statutory duty for about 25 years, I don't think. So my recollection is recollection rather than, so to speak, a quasi-expert talking about what I'm doing in 2022. Certain obligations are imposed on sometimes individuals, but certainly on government authorities and entities set up under statutory powers, including this inquiry. Those who act under those statutes owe duties, obviously, of care to conduct whatever they're doing in a proper way, but that duty is generally owed to the public at large, to government, rather than to individual specific plaintiffs. There are areas in which a statutory duty may give rise to a claim actionable by individuals. One of the early cases was about, I think it was the Yorkshire Ripper inquiry, whether the police owed a duty to the victims individually or simply a statutory duty to the public at large to perform their duty in the correct way. The general rule in this kind of case, where there are wide duties owed for the protection of the public, is that there will not be a duty owed to specific individuals unless there's something in the statute which says there should be. And I can give you an example which may sort of have some resonance from a different area, which is another case that I did involving the fire brigade. The fire brigade is there, they have a public function, they're there set up by statute to save lives and protect property. Generally, they will not be actionable, they will not have a duty to an individual in carrying out those duties. In the case with which I was concerned, it was decided, I was acting for another party, that because the chief fireman on the day decided that he would switch off the sprinkler system, then his breach of statutory duty was, if you like, was also a common law duty, and that was held to be actionable. It went all the way up to the Court of Appeal on the allegation no duty of care owed purely to the public at large, and failed. That's why in this case there was always a scope for department, health authorities, not just clinicians, to step beyond their role in performing their public functions and carry out an action which the courts would regard as having a direct impact on an individual and therefore being arguably actionable. So in general, statutory duty was unlikely to give rise to a duty of care owed to individuals. The duty was to perform for the public interest, and again, equally, in order to show that there was a breach of a statutory duty, you would have to show that the individual entity or minister or official acted in a way which is said to be unreasonable as opposed to merely negligent. The concept of Wednesbury unreasonableness, which is used in planning terms a lot, was that. And the Court of Appeal, you will know and you may have covered, concluded that there was unlikely to be a case in statutory duty here, but there might be, for precisely the reasons I've tried to identify rather clumsily.
Wednesbury unreasonableness is the concept that no individual, no minister, properly informed, could possibly have taken that decision reasonably.
Yes, which is several stages beyond. He made a mistake, and that mistake was negligent in that there was a failing of his duty of care. So you have to go that stage further.
In terms of the duty of care, and as you've described there, a distinction which was drawn in some of the papers is between an operational duty and
yes.
the policy duty. And am I right in understanding that the policy duty was the one that would have to be proved to Wednesbury unreasonableness standards? That's allocation of resources, decisions on major issues such as which project to pursue. But the operational duty, how a policy was implemented, would be actionable on the lower standard of negligence.
Assuming that it fell within the scope of duty because it was that side of the line, then it would be actionable on proof of negligence, yes.
And that is a line which is easy to describe here, but very difficult to identify in terms of individual parts of the claims. Is that fair?
Very difficult to identify, needs very considerable thought in anybody who's going to argue either side of the line, and is the sort of thing the judges will agonize over in working out. It's not easy.
You've described there the general concepts of the duty of care and breach of statutory duty. I'd like to ask you specifically about the importance of this issue to the Committee on the Safety of Medicines and the Licensing Authority. This is something that you address at paragraph 11.2 of your witness statement. But can I ask you just plainly why it was so important to the CSM and the Licensing Authority that a duty of care was not established in law against them?
Yes, I mean, the Committee on Safety of Medicines, and I don't know how much has already come out in the inquiry about this, was an assembly of 20 to 30 very eminent medical people of all sorts of disciplines. And they voluntarily sat on the committee and gave up their time to consider whether new pharmaceutical products should be licensed, whether any license conditions should be imposed, whether they should be withdrawn. And in doing so, they were balancing the interests of making medicines available, sometimes at the frontier, where there may be risks involved, and denying those medicines on the basis that they weren't sufficiently proven. And as we've seen with things to do with COVID over the last 2 years, where the process has moved incredibly rapidly, there is always a balance between something which is so important in terms of its therapeutic benefits that it should, if possible, be permitted to be marketed with appropriate warnings if necessary. But where there are signs of significant side effects which effectively change that balance from a balance in favor of making it available subject to safeguards to not making it available at all, or withdrawing its license, that requires exercise of judgment by all of those individuals. They all give up their time, and they're doing it, and they're looking, as they have to, not at each individual who might be affected, but at the balance between the benefit to the many of, this inquiry will know of the experimental drugs to deal with HIV, which have been so successful that they changed our perception of HIV. You have to have trials, clinical trials, animal trials, testing. There was a very clear system for the recording of adverse reactions and providing them to the committee. Now, in making those decisions, those individuals believed that they were acting for the public at large, assisting the Department of the Licensing Authority. But when I first addressed the Committee on Safety of Medicines in about 1985 or 6, when they were first brought into the Operan litigation, the concept that those individuals could be sued, even with a government indemnity, for their decision-making process, was a matter of real concern, because as opposed to trying to make a judgment for the overall benefit, reflecting the interests of each person who might be given that product, but also reflecting the risk to those who would be deprived of it, that was something which they needed to make without the feeling that they could be sued if they made the wrong decision. So it was really important to have that voluntary, effectively unpaid, I think they've not got expenses, system successful, that there should be no duty of care owed to individuals. The licensing authority would effectively, I mean, the licensing authority was the minister with about 2 civil servants attached for those purposes, and they would effectively follow the advice of the Committee on Safety of Medicines. And any departure from that would have raised inquiries and would have had to be very carefully justified. And that was the way in which the ministers delegated that difficult discretionary power to decide at what point a product should be licensed, cautioned against, side effects warned against, or withdrawn. That was their job, and the licensing authority had the formal job of approving or withdrawing the license as a result. And when licenses were withdrawn, on the one hand, manufacturers would scream, and on the other hand, those who were enjoying the benefits of the product in alleviating suffering would object. When Oprin was withdrawn, a number of people who found it very beneficial for their arthritis were very upset. So that's probably a long explanation of why it was considered very important that they should be able to continue to give that advice, operate in that way, without fear of individual actions being brought against them.
Can I just pick up on a couple of points from there? You said that the individual members of the Committee of Safety of Medicines would be sued. Is that correct, that it would be those individuals rather than the body itself that would face the action? I'm searching back in my memories to their precise legal status, but they were a collection of individuals who were appointed to be the Committee on Safety of Medicines. They were sued as such. But if you like, there was no company that could be struck off. So they were effectively those who made up the Committee on Safety of Medicines from time to time who would have been sued. And there was a very real concern that they would be named. I think at one stage it was Abraham Goldberg, who was the chairman of the CSM in Oprin. And I'm not sure that at one stage some of the writs weren't addressed to Sir Abraham Goldberg and the members of the CSM. There was no safe way of insulating them from the risk. Was there then a genuine sense that if the duty of care point was not successfully defended, then the system may struggle or indeed collapse because people would not volunteer to do this?
Yes, I mean, always dangerous to have that kind of sort of threat either perceived or given. But I do know, because I had in Oprin particularly 4 or 5 meetings, round rooms with 22 people, each with their rather old-fashioned microphones, talking into them when they press a button. And there was a very real sense that if we are going to be sued for this, we're just not going to be able to get people to replace us. We might see out our terms, but it's going to be very hard to do it. And that was certainly a view echoed by those in the department who were responsible for recruiting the next specialists. These were the most eminent people in their fields: virology, pharmacology, and I can't remember the disciplines anymore. But yes, it was a real concern that we wouldn't have what has been recognized as an incredibly thorough and effective system in terms of their input. Obviously, the extent to which adverse reactions are reported is variable and depends on people further down the chain. But I think it was a world-class system for licensing.
You mentioned in your statement that at this time there was a group of plaintiff personal injury lawyers who were, as it were, pushing the boundaries of the law in this area with the litigation that you've mentioned. Was there any reason, so far as you could tell, why it was that in the mid to late 80s this became such an issue?
Yes, I need to try and get back into that moment. I think, from my perception, and I've had some fairly strong views about this, there came across the Atlantic in the early 1980s the concept originating in the class action, which became the group action. In Oprin, there was a $6 million award given in one case by a jury in Texas, I think. the Operan plaintiffs tried to sue, I think, in the United States first, were told they couldn't. And Operan became the first group action where there were multiple plaintiffs. In pertussis vaccine, by contrast, it was an individual by individual approach, and that was a disaster. There were 2 cases which were tried. The case of Kinnear, which was Johnny Kinnear, which all the expert evidence was being given as to whether pertussis vaccine can cause brain damage, terrible consequences to the individual. And unfortunately, there was one spare afternoon when the judge said, well, let's hear from Johnny Kinnear's mother. And when she gave her evidence, it was plain that whatever else happened in that case, she could not succeed because of another condition. I don't remember the details. So the case collapsed, and they had another case, Loveday and Renter. So that's not a very efficient way of dealing with this kind of problem. The group of plaintiff lawyers saw the opportunity to bring the American form of class action, where you get lots of plaintiffs together, and the lawyers therefore can charge very large fees which no individual could possibly afford, as a way of increasing the size of their practices and bluntly making money. It had a dual function. Of course, they were there to try and represent the interests and promote the benefit of those who had suffered, but this was also a way in which they could succeed. Now, claims against pharmaceutical companies heavily defended. I think the concept was, if we sue the government, they may be a softer target. And there was, therefore, this tendency to bring the American blame culture across and to have massive claims for multiple plaintiffs against the CSM and the licensing authority, which, if successful, would have been very damaging. And of course, that went on into the other class actions. This was all legally aid funded, and benzodiazepine was a classic example where there were, I can't remember how many thousands of plaintiffs. But it came from America, and a number of firms grew very large and successful on the back of it.
One point I've been asked to put to you by some of the core participants is that if the claim for a duty of care against the Committee on the Safety of Medicines is successfully resisted, is there not what lawyers would call a lacuna in terms of the legal responsibilities of the CSM? How is that how is that circle squared? Is there a problem there in the fact that there is no legal oversight, as it were, of the CSM?
I understand the concern, I think the reason that there is no duty of care owed is because the function being carried out is one being carried out for the public at large, and therefore is not one which gives rise to a claim. I mean, we have moved in the last 50 years from negligence cases being comparatively difficult to the sort of where there's blame, there's a claim mentality. It was not at all unusual at that stage that genuine suffering would not give rise to a claim. If there's been negligence somewhere down the line, then it does. And of course, there are 2 aspects there. First of all, if the clinician doesn't give the appropriate warnings or doesn't consider the warnings when deciding whether to treat their patient in a particular way, they will be at fault and there will be a claim. But there are certain things. If the fire brigade comes and arrives too late, they have no duty of care. It burns down, there is no recourse. If there was a position where 25 men made a mistake, then the question is, well, why shouldn't they be sued? Why shouldn't we have damages for that? But of course, the concept of duty of care in professionals following the Bolam standard, I'm sorry, it's back into law again, is that it's got to be a decision not that no reasonable minister, that's the Wednesbury test, but no reasonably competent professional in that position would do, or no opinion they would hold. When you've got 20 or 25 or 30 eminent people and they all collectively decide to do something, then the legal standard for no reasonably competent practitioner would do it could only be met in the most extreme circumstances. They all went out to dinner and got drunk and had a licensing day the next day and passed the papers through without reading it. There would probably be a cause of action then, because that would be an operational action. But when they all get together and they think and they read the papers and they debate and they decide, then it must follow, in my view, that you cannot say that no reasonably competent person would have done it. So even if there was a duty of care, then you would fail on negligence on that test because they've considered it. Again, you have to have a position. If there's something they haven't considered, a piece of information which has been missed, then that's probably something which the department failed to provide to them, and that would be an operational duty of the department for which there would be a cause of action in negligence. So there isn't, I don't think, a lacuna of real significance. Where there are situations where the law does not give a remedy, and the law is, I'm afraid, a pretty rough way of trying to do justice, because it has to be, it can't cater for everything, and judges as well as lawyers are human, then there is that gap, and that is where government action, if appropriate, is needed to intervene. And that's an area you may discuss later, which I have some pretty strong views on.
Well, we will come on to that shortly. What I'd like to do now is take you to an advice that was written by Andrew Collins in October 1989. Can we have on screen, please, Paul? DHSC 306484_012. If we could have the second page of that, that's just the facts summary. We can see it is entitled Liability of the Department of Health and of the CSM in respect of personal injury caused by licensed medicinal products. Advice. Paragraph 1 says the need for this advice arises from two actions which are currently being pursued against the Crown. The first is the so-called HIV haemophiliacs litigation, in which a master statement of claim has been served alleging breaches of duty and negligence against the department, both as licensing authority and as having responsibility for the provision of medical services under the National Health Scheme, the CSM, and the regional and other health authorities. The allegations against the department as licensing authority in the CSM are based on failures to vary or revoke licenses because of the known risk of hepatitis, the granting of licenses to non-heat treated factor VIII concentrates, and a failure to appreciate in time the AIDS risk. Similar allegations are made against the CSM in that it failed to give the necessary advice which would have led to the removal of the offending product from the market. I won't go on to read the rest of that paragraph, but if we could move on to the second paragraph, please, on page 3 of the electronic document. The second group of actions, although only one has so far materialised, is a claim by a plaintiff who alleges that he has been injured by becoming addicted to Valium, benzodiazepine. It is said that the Department of the CSM ought to have warned of the dangers of dependency. So this advice is being given in respect of both of those actions. If we, Paul, could go briefly to the page 14 of the document. There is a redaction over the initials, but they are AC, and we know from those initials and from the address of the chambers that is Mr. Collins, as he then was, 18th of October 1989. So that we have some context. We heard from David Mellor last week that at around this time he was questioning whether or not the duty of care point should be taken at least by the Department of Health. And the CSM and the licensing authority were also giving their views on that. First question arising from this. why was it that this advice was given about both of the actions rather than just the HIV litigation?
I don't know why it was. I can reconstruct at that stage because the attack on the CSM and the licensing authority and the opera litigation had raised these real concerns which we've discussed, but had been successfully, I think, by this stage, fought off. And it arose in two contexts. One, small group of plaintiffs, haemophiliacs, very, very serious consequences. The other, very large group of plaintiffs, usually much more mild consequences, addiction to Valium, raised the possibility that this was the next wave of the onslaught of trying to impose a duty on the licensing authority and the CSM, which would enable a claim to be brought against the public purse through the CSM every time a medicinal product proved to have unexpected side effects and unexpected consequences. And that was regarded as very serious and needed to be looked at, I think, together so that there was a consistent view taken between the two. And in a sense, as I put elsewhere, I think in my advice, the combination of CSM and licensing authority with the department raised a difficulty. The combination of claims for benzodiazepines being brought, I don't think necessarily by exactly the same group of lawyers, but there was some overlap at the same time as this, meant that the consequences of any decision taken as to the way in which the cases were to be handled and the consequences of the imposition of a duty of care in either was much wider than just limited to the haemophiliac case. So it was an unnecessary and, in retrospect, unsatisfactory aspect that the importance of preserving the position for the CSM and the licensing authority separately from the department was all the stronger because of this perceived risk of benzodiazepine and further claims down the line being brought. Benzodiazepine being a relatively mild condition, such as Operan, being brought in the same basket as these much, much more serious matters with all the terrible consequences which you've heard so much about.
I'm not going to go through all of this advice. The general tenor of it is that the duty of care point should be taken for the Department of Health and the licensing authority and CSM.
A duty of care point.
A duty of care point. The case for the latter, the licensing authority and the CSM, was particularly strong.
Yes.
I'm just going to take you to electronic page 13 and paragraph 9. This is towards the end of the advice. This is from Mr. Collins. I emphasise that you weren't a signature to this advice. I should add that, from the information I have seen, I think that there are reasonable defences to all claims on the merits. But I am sure that the existence and, if it exists, the extent of any duty of care must be settled, and these cases are the vehicles to enable that to be done. Once the decision has been made to leave it to the courts, it must be dealt with properly, taking all properly arguable points. Am I right to read that as a fairly strong steer to ministers from Mr. Collins that you should be left to run the duty of care points that you thought were properly arguable?
But I'm sorry, could you repeat that?
Am I right in reading this as being a fairly strong steer to ministers from Mr. Collins that the lawyers should be left to run the duty of care points that they considered to be properly arguable?
I don't think I'd put it quite like that. I mean, Andrew was always robust He came from a family tradition of robustness. His father was Dean of St. Paul's and a leading member of the CND, and Andrew followed in his trenchant views. I think what was being said here is that despite the fact that there was a reasonable defence on the merits, irrespective of the legal duty, it was necessary, with claims being made, particularly against the CSM and licensing authority, that the existence of of such a claim and its nature, if it existed, needed to be determined for the future, because otherwise, if you say no duty, nobody's just going to go away. The lawyers were keen to run the point, and if it were conceded, then there would be serious consequences. So, since it was clear that you couldn't just say, well, let's put it to one side, you had to take the point. Once you decide to take the point, the government lawyers, and that is everybody from the Attorney General and Solicitor General who'd be consulted down through the departmental lawyers and the counsel team, should be instructed to take the point. And if you take the point, you have to take it seriously. You don't take it half-heartedly. If you can take it half-heartedly, then you should waive it.
I'm going to take you to one more piece of this advice as well. Electronic page 9, paragraph 7.3. Paragraph 7.2 concerns the legal arguments about whether or not there is a duty of care owed by the CSM, and there have been similar discussion about duty of care owed by the department. In 7.3, Mr. Collins wrote this. If this is right, his legal analysis, there is no alternative defendant in the haemophiliac cases, and they will not be compensated through the courts. I note that a decision has been taken not to compensate them in other ways, for example, a scheme such as applied by the Vaccine Damages Act. There is, I think, much to be said for some such scheme to compensate those who fall victim, through no fault of their own, to a medical disaster. But that is a political and not a legal problem, although a sympathetic judge may be persuaded to take account of the absence of alternative compensation in deciding whether there is a duty of care, that being one of the surrounding circumstances. First of all, did you agree with that paragraph, the sentiments expressed in it?
I can't remember whether I put in my statement. I would never have quite used the trenchant language of Andrew, who was pretty senior and I was pretty junior, and still fresh from the army, where we did what we were told as opposed to saying what people should do. I entirely agreed with the concept, and throughout my involvement in this is one of my strong recollections. It is really important that part of government's function is to look with care and love at all those in its constituency. And where there is a legal claim, there is a legal claim, and you deal with it under the law. Where there is not, you then have to consider the human and the resource and the policy case. You cannot compensate everybody who is the victim of misfortune. That is impossible in a society with limited resources. Therefore, if you have a really serious misfortune, and there are many medical misfortunes as mistakes have been made and knowledge is learnt, things you could have done 20 years ago if somebody had realized it and then it's discovered. But government should be there to make political decisions where there is an absolutely massive case for some form of compensation of an extra legal sort. And I mean, that certainly informed my view throughout. and we see it happening, whether it is aid to Ukraine or whether it is aid to victims of disasters at Aberfan or anywhere else, that is a function of government to fill in the gap between what the law will do and what it is proper to do. But the question of what it is proper to do is a political decision, not a legal decision. And that's why I was always careful not to push my views down the throat of those instructing me in the way that Andrew probably felt able to do so, but to make clear we're never asked my view. And you'll come on to it, but my absolute overriding view was that in this case, the plaintiffs would all fail. They would all go through the agony of a trial, and they would lose and get no compensation. But such is the terrible nature of the consequences on this already much afflicted group of people, that at the end of it, the public outcry for compensation would have been all the louder, and the government would have ended up paying lots of money to lawyers, which is not a thing I'm very keen on, and then having to spend more money on compensation because of the outcry. And my view is I'd rather have all the money go in compensation than dispense with the lawyers.
I'm going to finish on the duty of care point by just briefly going to a further document, which is DHSC 0041 034 underscore 007. It's dated the 24th of October 1989, so a few days after the advice that we were just looking at. And it is a submission from Sue Armstrong, a solicitor to Mr. Wilson in the Department of Health. And it's about the duty of care and how it should be run in the litigation. If we look at the second paragraph, we see it's written, counsel advises that it will be very difficult to take the point in the Valium and not in the HIV. Questions would inevitably be asked as to why we were doing so, when the issues vis-à-vis the licensing authority and CSM are identical. This could in itself cause bad publicity about the department's attitude to sufferers from tranquilizer dependency. Then we have a paragraph talking about a potential variation. Then we have this. Counsel has suggested the following approach. 1, we take the point on behalf of the licensing authority and the Committee on the Safety of Medicines in both. 2, so far as the department goes, in HIV, we raise the issue of allegations that go to questions of policy and attempt to strike them out as non-justiciable, leaving the other aspects of the department's involvement, i.e. its administrative, operational function, intact. In this way, perhaps, the government would not be seen as eroding its responsibilities, but merely directing them towards the right quarter. It would also reduce the complexity and cost of the litigation, thus assisting the plaintiffs to some extent. Do we take from this that the advice then is that to run the duty of care point in full for the Committee on the Safety of Medicines and the licensing authorities, but to draw that distinction that you were talking about earlier between the operational and the policy distinctions for the Department of Health?
Yes, and I mean, just to illustrate that, a policy decision as to whether you go for earlier self-sufficiency in like products and factor it, and the resources you put to it is a policy non-justiciable. When you decided what you're going to do, the way in which the department goes about it, and the speed at which it does so, and any failure to make progress or look at avenues can go into the operational side. So there is a remedy for the failure to do what policy decides competently and in a timely manner, but the actual policy decision is outside the remit of the courts.
And the constitutional principle behind that is that the democratically elected government is responsible to Parliament for those political decisions.
Yes.
And to the best of your knowledge, is this the approach that was then taken for the rest of the litigation on behalf of the defendants?
Yes, I believe so. I've seen nothing. I mean, it sounds right, and I've seen nothing in what you sent me to suggest that we changed.
Just to conclude on this, paragraph 17.2 of your statement, you state that there was a decision by Mr. Justice Ognall not to try these matters as preliminary issues on the 5th of December 1989. Now, that is something that both the plaintiffs and the central defendants had wanted, but other defendants had not wanted. And Mr. Justice Ognall said, we're not going to have a trial of that now. We will try everything together in due course. Is that a fair summary?
Yes.
I'm going to move on then to a conference that you had with the Department of Health and those representing the Department of Health and the Committee on the Safety of Medicines and the Licensing Authority on the 19th of October 1989, so at the same time as this discussion was taking place. We have, first of all, I won't ask for it to be brought up, but there is a reference which is not in your statement, so I give it for the transcript. DHSC 0019630, which is in effect an agenda for the conference, which was sent by letter by Mr. Powell, sent to Mr. Desai, but also to you. And he said that he wanted to consider three issues: levels of compensation if the case is lost, advice on the likelihood of a success on the preliminary issues before going on to consider settlement, and thirdly, the Sunday Times campaign for compensation that was running at the same time. It's that issue that I'd like to pick up on in particular.
Yeah.
If we could have on screen, please, DHSC 0041034_015. This is a note that was made of the conference by somebody who attended. It's not signed. You say in your statement at paragraphs 14.12 that this was a rather sketchy note, and you express some concern about relying on this rather than on the written advices that you gave during the hearings, and that is something, of course, that we will keep in mind. But if we could just go down to the bottom of that page, the final paragraph. What is recorded in the note is this. Regarding the articles appearing in the Sunday Times, counsel said that these were tiresome and show that the plaintiffs know what is going on, but the articles do not amount to contempt. The articles might be an attempt to influence the trial judge. All the articles boil down to saying is that the government should provide compensation. Counsel has told the other side that they should be careful what they say in the Sunday Times. In answer to a question from Mrs. S. Armstrong, solicitor, counsel said that press publicity in Opron litigation was distinguishable from the present press publicity because in Opron, the court had a supervisory role and the object of the press cuttings was to influence the court. Counsel said that there might be contempt of court if there is a repeated and persistent campaign, but contempt of court has not yet been committed. Counsel advised the DHSS to get the previous judgment of Mr. Justice Hearst and pass the press cuttings to the trial judge, Mr. Justice Ognall. Are you able to recall now what that issue in the Opron litigation was in respect to the press?
No, I can't remember specifically. I mean, in the Opron litigation, to my recollection, and because this became a frequent approach of plaintiff lawyers in this kind of litigation, there was an attempt to run a press campaign in parallel with the legal proceedings in order to seek to influence the court of public opinion and those who are decision makers. And it happens all the time, and people do it. Plaintiffs will often try and engage the press, try and get them there, try and if the sort of stuff I do now about big commercial cases, try and get public sympathy for the conduct of the defendant or whatever it may be. In this case, by running it in parallel with the litigation and effectively suggesting that this was the only correct outcome. There was no doubt that there was a hope that this would influence both the judge and the defendants and government into taking an approach which was not strictly legal. And it's perfectly justifiable. I've seen it happen. I've seen opening days, the opening day of the Human Growth Hormone trial, there were about 60 press people there. Nobody left at the end. So press campaigns are used as a vehicle in litigation. I deplore the habit. I understand why people do it. I don't recollect what it was that made, by the look of it, Mr. Justice Hurst say something about it. I suspect the manufacturers took a point in opera, and it would be more their style than the government's to take a point and say you shouldn't be doing it. I think the department, as many defendants, particularly those public servants, are uncomfortable with publicity, hence raising this question.
Did you feel either then or at any time during the litigation that the department was taking an inappropriate attitude towards press coverage?
No, because it didn't do anything about it. I mean, it's human nature not to like it. It doesn't actually help the decision-making process, whether within the department, it, puts potential witnesses off track. It's diversionary. You're doing litigation. You're trying to get the best evidence in order to present the law and the facts to the court, and it's a distraction. So they didn't like it. Is it inappropriate of them to say, can we do anything to stop it? I think defendants do that all the time. Did we take any steps to do anything? It looks as though we may have made sure that Mr. Justice Ogdenall was aware of what was being said in the press if he didn't read it over his Rice Krispies in the morning. Is that inappropriate? In my view, no. Had we tried to muzzle it, written to the court and asked them to restrain it, try to put pressure on it. No, I don't know what, if anything, happened between Andrew Neil, I think was the editor in question, and any influential people within government. But I'm not aware of anything which crosses the line between disliking publicity and enduring it.
Moving on to a separate part of a note then. If we stay on the same page, please, electronic page 2 of that document. 4 paragraphs down, there is a discussion of the slightly gnomic comments on the merits of the case and the issue about preliminary issues being tried. But then right at the bottom, just the final 2 sentences. Counsel feels that the plaintiffs will lose the case. Ministers, he felt, should consider compensation. This is not your note, but doing the best you can looking back on it. That second sentence, ministers, he felt, should consider compensation. What do you think you were saying in the comment?
I think I was almost certainly saying what I've said already, I think, today, which is that from what I knew about or believed to be the case about legal duties, which we've covered, the extent of duty of care, what I had seen of the documentation and the difficulty of proving an actual breach of duty if there was a duty at all, and the problems of causation, I was confident is a wrong word, but I was strongly of the view that the claims would fail as a matter of law, and the judge would have to dismiss the claims on the law. But because, the simple fact of haemophiliacs suffering from HIV is poignant and tragic enough in itself. If you have a trial where victims and their family are recounting the consequences, you will get an outcry for compensation. And the reason you get an outcry for compensation is not a sort of bad thing we want to try and avoid. It's because there is a really strong case for compensation. And therefore, it's not my job as a lawyer to say, as a matter of policy, you should compensate. It is my job as a lawyer to say, there is a huge compassionate case here, and my best judgment is that the consequences of a trial would be an even greater outcry, and one which ministers would find it very hard to resist, particularly because it spanned two administrations, and so it was not going to be a party and party issue, it was a cross-party issue. And it's exactly, you don't simply get closure because the case is lost and everybody goes home, because the haemophiliacs and their family are still there. So that's the kind of thinking which I had throughout and which informed my view of subsequent litigation. And I was probably saying that in probably less sophisticated terms because I was 30 years younger.
I note from the transcript that you also deal with this point at paragraph 14.6 of your witness statement, to which people can refer later. Do you recall what response you got from the civil servants and the instructing lawyers when you made these kind of points? Was there any pushback that you shouldn't be going there, you should just be giving us the legal advice?
No, I don't think so. I mean, there is a distinction between that which they recognized and took on board, and there was a feeling which comes through the papers you sent me, that we need to be very careful before we go down the route of ignoring whether or not we have a legal liability, because you get the floodgates argument. So there's always a balance between trying to do the right thing for a particular group and creating a precedent. So, and then there is the question of when you advise ministers, what do ministers do about it? You don't advise ministers, we have no liability, you should be paying. It's like saying to an insurer, as an advisor, this insurance policy does not cover this claim, but they're nice people and they've had a disaster, so you should pay. You have to say what the law is, and insurers and government ministers and departments will, on the whole, expect you to hold the line of legal liability until or unless someone decides to do something different. So these were comments deliberately not based on, I think you as a minister or as a department should pay. It's, I think that these will be the consequences, so I as a lawyer can legitimately tell you that this case is so strong compassionately that if we win it, you will still lose in the sense that you'll have to compensate them.
You've described today and in your statement your personal sympathy for the plaintiffs and what they have been through. Did you get a sense that that sympathy was shared by those who were instructing you, the civil servants and the solicitors?
Yes, I mean, I have to distinguish in my memory between this, human growth hormone, and variant CJD, because after 20 and 30 years, they do tend to merge together. I think everybody was acutely aware of the unique situation of the haemophiliacs. It's desperately difficult condition, the hereditary nature of it, and this blow of what is not only an appalling condition where we all believed that everybody who became HIV positive would die in a very short period, but in addition, the social stigma attached to HIV because of its origins put them in a special case. And I think everybody recognized that. there is a distinction because the department, of course, had to deal with lots and lots of cases of medical problems and things that go wrong, whether it's complaints about shortage of supplies in hospitals and people dying because they're waiting for treatment. So there has to be a slightly harder edge. But I have no doubt that the haemophiliacs were particularly recognised by the department as requiring sympathy, whatever the legal consequences had to be. And it was a tension between the need to preserve A, assets and resources for the right thing, B, the legal precedent, and C, do what one can. And you see that. You missed out a paragraph, I think, somewhere earlier, about an accretion to the McFarlane Trust.
Yes.
So the government was doing something outside litigation. And that was, I think, a recognition of the sympathy the department and everybody else and ministers had of this situation. So that's probably a rather long answer, but that's my recollection.
Just so that we have it in context, the McFarlane Trust had been set up the previous year, and shortly after this conference, this is in October 1989, in November 1989, a further payment was made to the McFarlane Trust. So I note for time, and I'm about to move on to a different topic.
Yes, well, we'll take a break now until 11:45. You'll know what I'm going to say now. You're giving evidence. You must not discuss the subject of your evidence with anyone, whoever that person is. You can talk about anything else you like. And that, of course, applies at all breaks. 11:45.